Welcome to the participants of the JCJ AP 2023, the screening test, which is going to be held on 7th January 2023. Participants, anyone can unmute and read what I posted on the screen. I posted something on the screen. Could you see it? Could you see the screen, what I posted on the screen? Please read.
Welcome to the aspirants of AP JCJ 2023 screening test for the online class on 9th December 2022. What are the important IPC sections that every Indian should know?
Good. And later on that my name is given over there. So without wasting the time, let us go to our exercise. And this is the thing which I already made. Yes. Now let us start it. Be ready. Andhra Pradesh Junior Civil Judge 2023 screening test to be held on 7th January 2023. Indian Penal Code, multiple choice questions, dated today, 9th December 2022 online class. The first question. Match the following section in Part A with its explanation in Part B. Part A, Section 499, 2, Section 503, 3, Section 506, 4, Section 509. In the Part B under A, punishment for the criminal intimidation, B, word, gestures or act intended to insult the modesty of women, C, defamation, D, criminal intimidation. Now the options goes in this way. Option A, 1B, 2C, 3D, 4A. Option B, 1C, 2D, 3B, 4A. Option C, 1C, 2D, 3A, 4B. Option D, 1D, 2B, 3C, 4D. Now which is the right answer?
C.
Option C, sir.
Yes, you are right. It is an option C is the right answer for the first question. And the feedback is Section 599 is the defamation, Section 503 is the criminal intimidation, and 506 is the punishment for the criminal intimidation, and Section 509 is the word, gestures or act intended to insult the modesty of a woman. So that is the right answer. The C is the right answer for the first question. What is meant by gestures? Anyone? Supplementary question. Gestures.
Like preparations to cause.
Like signs, sir. Signs.
A body movement showing the something and which conveys instead of words is called the gestures. Like raising the eyebrows shows the explanation. It's the doubt, maybe, and there is a specific word is there, raising the two eyebrows up. It is called frown, F-R-O-W-N, frown. Means raising the two eyebrows as in the form of a doubt, maybe, or some exclamation. So that is the thing. Okay, now let us not waste the time. Second question. Match the following chapter in Part A with its explanation in Part B. Part A, Chapter 20, Chapter 20A, Chapter 21, and Chapter 23. Part B. A, of defamation. B, of attempt to commit offense. C, of offense relating to marriage. D, of cruelty by husband or relatives. Now I am giving the options. Relatives are the husband. So the options are A, 1B, 2D, 3A, 4C. B, 1A, 2B, 3C, 4D. C, 1C, 2D, 3A, 4B. D, 1D, 2C, 3B, 4A. Which is the right option? Here I have given this thing. And options are here.
Option C, sir.
You are right, it is an option C again. The match the following. The feedback is Chapter 20 of offense relating to marriage. Chapter 20, capital A, of cruelty of husband or relatives of the husband, chapter 21 of defamation, chapter 23 of attempt to commit the offenses. Shall I proceed? Say yes. Shall I proceed?
Yes, sir.
Good. Third question. Match the following section in part A with its explanation in part B. Part A, 1, 489, 2, 489 capital A, 3, 489 capital B, 4, 489 capital C. In part B, A, counterfeiting currency note or banknotes. B, tampering with the property mark with the intent to cause injury. C, possession of the forged or counterfeit currency notes or banknotes. D, using the genuine or forged or counterfeit currency notes or banknotes. So options goes in this manner. A, 1B, 2C, 3D, 4A. B, 1B, 2A, 3D, 4C. C, 1A, 2D, 3C, 4B. D, 1C, 2D, 3B, 4A. Which one is the right option?
Option B, sir. B.
Option B, sir. Option
Repeat.
B.
B.
B. 1B, 2A, 3D, 4C.
You are right. The answer is B, 1B, 2A, 3D, 4C. And here I am showing the feedback. 489, tampering with the property mass with the intent to cause injury. 489 capital A, counterfeit currency notes or banknotes. 489B, using as genuine, forged or counterfeit currency notes or banknotes. 489C, possession of the forged or counterfeit currency or the banknotes. So that was the answer. Now let us go to the fourth question. Which section of IPC says mobile property? Option A 20, option B 21, option C 22, option D 23.
22, sir. C.
Appreciate it is the 22 is the right answer for that. Yes, the fourth question, the right answer is 22, that is the C. Now next, fifth question. The word mobile property are intended to include, find the false one. What is the false one? A, corporeal property of every description. B, except the land and things attached to the earth. C, permanently unfastened to anything. D, which is attached to the earth.
Option D, sir.
WRONG.
Option B, sir.
WRONG. Option D is wrong.
Option B, B.
WRONG.
A, sir.
WRONG. Then what is left? Then what is
C, sir.
left?
C, sir. C.
C is the right answer because permanently not unfastened, permanently fastened to anything. So that was the way. So now the sixth question. Match the following section part A with explanation in part B. Section A 376, 2 376 capital A, 3 376 capital B, 4 376 capital C. Section B. A. Punishment for causing the death or resulting in a persistent vegetative state of the victim. B. Punishment for rape. C. Sexual intercourse by a person in authority. D. Sexual intercourse by husband upon his wife during separation. Options goes in this way. A. 1B, 2A, 3D, 4C. B. 1C, 2B, 3D, 4A. C. 1B, 2C, 3D, 4A. D. 1D, 2C, 3B, 4A. I show the here the again. Now I am showing the options.
Option A, sir.
Yes, you are right. Option A is the right answer. 1B, 2A, 3D, 4C. And feedback is 376, punishment for rape. 376 capital A, punishment for causing the death or resulting in a persistent vegetative state of the victim. 376B capital B, sexual intercourse by the husband upon his wife during the separation. 376 capital C is sexual intercourse by a person in authority. Now I will ask the supplementary question. What is the vegetative state? I repeat, what is the meant by vegetative state? Anyone? If you don't know, you say pass on. But I can give the hint. I think it is a Nagarjuna played one of the role in that movie, and in Hindi, Hrithik Roshan played the role. They are in vegetative state.
Brain dysfunction.
Yes?
Brain dysfunction.
Not exactly the brain. They could understand everything, but they cannot move.
Brain damage.
Bedridden. They cannot move. Even everything should be done in the bed. What is the Hindi movie? What is the Telugu movie? Of course, it is not going to be asked, but they are in vegetative state. I think it is a Nagarjuna in Telugu, Hrithik Roshan in Hindi. Okay, now let us see the seventh question. Crimes and wrongs whose sanction is positive and in no way remissible by any private person, but remissible by a state alone, if remissible at all. A, according to Kenny, the definition given. B, according to Fraser. C, according to Salmon. D, according to Winfield. And who has given the definition? I made the option A, B, C, D, shoot.
C, sir.
Wrong. Second option.
Option D, sir.
Wrong.
A, sir.
Yes, according to Kenny, crimes are the wrongs whose sanction is positive and in no way remissible by any private person, but remissible by state alone, if remissible at all. The eighth question. Polygamy, man having more than one wife, was not an offense among the Hindus till option A, 1952, option B, 1953, option C, 1954, option D, 1955.
Option D, sir.
You are right. I could appreciate. Can you tell me what is another significance of the 1955? An act is made.
Hindu Marriage Act, sir.
Yes. So here again the question is, I am going to read. Ninth question. However, with the passing of the Hindu Marriage Act 1955, polygamy in any form was completely outlawed among Hindus. Therefore, the content of crime changes with the dash. Option A, emerging of time. Option B, revolution of time. Option C, evolution of time. Option D, change of time. Which is the appropriate word among the ABCD?
Option C, sir.
You are right. It is an option C. Evolution of time is the appropriate word. As the evolution of time, the law should be changed in the same pace with the society is changing. That's why we can say law is an instrument for the social change. So now let us go to the 10th question. Which one is a true statement? Number 1, crime is not a civil law. Number 2, crime is not a moral wrong. Number 3, crime is a basically disobedience of the penal law. Number 4, the object of criminal law is a criminal retribution. Now here give an option. A, option 1 plus 2 plus 4. B, option 1 plus 2 plus 3. C, option 1 plus 2 plus 3 plus 4. D, option 1 plus 3 plus 4. Which one is the right true statement?
C, sir.
Wrong.
Option B, sir.
B, sir.
Option B. The reason is crime is not a civil law, it's true. Crime is not a moral wrong, it is true. Crime is basically disobedience of the penal law. It's true. And the fourth one, the object of criminal law is criminal retribution. It is not the criminal retribution. It should be the punitive penal retribution. See your feedback I have given. The object of criminal law is penal retribution. I removed the penal and I put the criminal. And that's why the answer is B, 1 plus 2 plus 3. Is it clear? Say yes.
Yes, sir.
Okay, now I'm proceeding to the 11th question. Which one is the true statement? Number 1, crime are not civil wrongs. 2, in a civil wrong, the defendant is liable to pay the compensation to the plaintiff. 3, this is because the object of civil law is to restore the plaintiff to his or her original position by compensating him. And what is this sign which I made him? What is this sign or symbol? Professor Hussain students never say it is a slash. Professor Hussain students never say it is a oblique. Professor Hussain students never say it is a stroke. Professor Hussain students say it is a virgule. Virgule, virgule. Is it clear? Now let us give the options. Fourth option, the object of civil law is a natural justice. Now here I have given the options, which is a true statement. Option A, 1 plus 2 plus 4. Option B, 1 plus 2 plus 3. Option C, 1 plus 2 plus 3 plus 4. Option D, 1 plus 3 plus 4.
Option D.
Option D, sir.
Read the full.
1 plus 3 plus 4.
3 plus 4.
WRONG.
Option A, sir.
WRONG. Hunch.
Option C, sir.
WRONG. Then what is left? Then what is left?
D.
B.
1 plus 2 plus 3.
It is a B, 1 plus 2 plus 3, because crime are not civil wrong. True. In a civil wrong, the defendant is liable to pay the compensation to the plaintiff. It's true. This is because the object of civil law is to restore the plaintiff to his virgule her original position by the compensating him virgule her. And the fourth one is the object of civil law is natural justice. No, wrong. It should be restorative justice. The object of civil law is restorative, means bringing back to the original position as if no offense is committed against him. Is it clear? Say yes. Say yes.
Sir.
Shall I proceed?
Yes, sir.
Very good, very good. I should get the answer from you. Otherwise, I told you now 3 stanzas. Okay, now 12th question. Which option is correct? 1. Moral wrongs are not punishable. Number 2. Moral wrongs do create a claim for compensation. Number 3. There is no liability for a person who commits a moral wrong. 4. For example, disobedience of parents is a civil wrong. The option which I have given is A, 1 plus 2, B, 1 plus 2 plus 4, C, 1 plus 2 plus 3 plus 4, and D, 1 plus 3. Which is the correct option among the ABCD? Again, I will show you. 1, 2, 3, 4. Read. Then you see the options here. Now shoot.
D, sir. D. 1 plus 3.
Wrong.
Option C, sir. 1 plus 2 plus 3 plus 4.
WRONG. Check it here. Moral wrongs are not punishable. It is true. Moral wrongs do create a claim for compensation. Answer is it won't. Is it? Is it?
Don't create a claim. No, sir.
And there is no liability for a person who commits the moral wrong. It is true.
Yes, sir.
And disobedience parents is a civil wrong. Answer here, you have given two are wrongs here. Moral wrongs don't create a claim for compensation. What I wrote? Moral wrongs do create a claim for compensation. So that is wrong. Is it or not?
Yes, sir.
Okay. Now, of course, here the wrong one is, see, 2 is wrong. And next, for example, disobedience of parent is a moral wrong. But here I'd say a civil wrong. So the right option is, I think I made the wrong statement here. So right answer is, the 2 are wrongs here. 2 is wrong and 4 is wrong. Then right one is 1 plus 3. D is the right answer. You said is the right. What you said is the right earlier. So D is the right answer here because 2 is wrong and 4 is wrong. Is it clear? Say yes. So the D is the right answer. Okay? Shall I proceed?
Yes, sir.
Good. 13th question. Can anyone unmute and read 13th question?
The burden of proving a crime is on the A. State, B. Competent court, C. Accused, D. Prosecution.
And D, sir.
D, prosecution.
Option D.
Appreciate. The burden of proving a crime is on the prosecution. Strictly speaking, though no doubt the state will do it, but state will not make it. Through the prosecution it can be done. Anyone can unmute and read the 14th question?
Which one is the correct statement? Number 1, the prosecution must prove the guilt of the accused. Number 2, and that to be behind a reasonable
Beyond.
beyond a reasonable doubt. Number 3, if any doubt is present in the mind of the court. Number 4, then the court shall have to acquit the accused. Answers: A. 1 plus 2, B. 2 plus 3, C. 1 plus 2 plus 3, D. 1 plus 2 plus 3 plus 4.
Option D, 1 plus 2 plus 3 plus 4.
You are right, Sri Devi. Here the answer is, I made the confusion in the above, but here everything is right. The prosecution must prove guilt of the accused, number 1, and that to be beyond the reasonable doubt. And 3, if any doubt is present in the mind of the court. And 4th, the court shall have to acquit the accused. What is the maxim is there? One maxim is there. I don't know who wrote that maxim. Lord Cook, Lord anything, because myself also forgotten. The maxim is, let 99 convicts
Accused.
guilty should be released, but one innocent cannot be convicted.
Convicted.
Who said? Because that may be going, it is a simple question. That's why I did not ask, because several times I asked such a question in my earlier things. So I did not repeat it. Please note the point, supplementary. Some places, no, let the 9 convicts will be acquitted, but one innocent cannot be convicted. Okay, please note down who said such a statement. That is the reason in the criminal law we say beyond the reasonable doubt. But in the civil law, we will say preponderance of evidence. Based on evidence. Then a supplementary question, another. If a person is acquitted in the criminal case, it does not bar for the civil case. Please note that point also. So 15th question, criminal trials are, I repeat, 15th question, criminal trials are dash in nature. A, controversial in nature. B, typical in nature. C, multifaceted in nature. D, adversarial in nature.
Option A,
Option
sir.
D.
Answer B, sir. Typical.
WRONG.
Option D.
Read full.
Adversarial.
Adversarial.
You are
Adversarial.
right. Criminal trials are adversarial in nature. The right answer for the 15th question is D, adversarial. So 16th question, which one is correct statement? Number one, the element of the crime is the human being. Two, only human beings are liable for their criminal acts. Three, in general, animals or plants are not liable under the Indian Penal Code for causing harm to humans or each other. Four, only humans are liable in general under the Indian Penal Code. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4. Which one is the right answer?
Option B. 1 plus 3 plus
Option D,
4.
sir.
Answer D, 1 plus 2 plus 3 plus 4, sir.
Wrong.
Option B. 1 plus 3 plus 4.
I doubt because let me check it one after another. The element of the crime is human being. Yes, it is acceptable.
Yes, sir.
Only human beings are liable for their criminal acts. Yes, it is acceptable. That means
Yes, sir.
1 plus 2 is acceptable. Is it or not?
Yes, sir. Yes, sir.
So,
In general,
in general, animals or plants are not liable. It is also acceptable.
yes, sir.
Is it or not?
Yes, sir.
And only women are liable to in general under the Indian code is also acceptable. Is it or not?
Yes, sir. 1 plus 2 plus 3 plus 4.
Wrong. You missed one point. When you said the element, it is not the element, the first element of the crime. It is not the element. It is the first element of the crime. That is the appropriate word. See, in the feedback I have given. The first element of the crime in a human being. So the right answer is
C.
C is the right answer. See, in that way also they can ask the question. We never say the element, the first element. So I removed the first and I put the definite article the there. So one should be very much careful. Okay?
Sir.
Now,
Sir.
okay,
Sir,
17th question.
Sir,
17th
can
question.
I ask?
Yes, please.
Sir, what is the first element and the element difference? Can I know the difference?
Yeah,
between
because the is a definite article. When the definite article is there, you should have to specifically mention the definite thing. Means the first, not the element. The element, which element?
there is
The
no
first
specification.
element. Because the is a definite article and hence we should have to use the first. Is it clear?
Okay. So it is
One should be good in the grammar also.
grammatically.
The grammatically also they will check it. See, one more point. Here I'll show you. 17th question. Which one is the correct in total? A. Actus non facit reum nisi mensitria. B. Actus non facit reum nisi mensitria. C. Actus non facit ritum nisi mensitria. D. Actus non facit reum nisi mensitria. Please concentrate on each and every letter of the maxim. Then you can shoot.
Let's see the ending.
Option A, sir.
It
Option A.
is A looking like right, sir.
Wrong. See, both are right. A and B are right.
A and B are also
Actually,
right.
which is the right way means, see, the
Font
both
is different.
same
Font is
spelling,
different.
no change. But in the three, see, there I made the change, at least facet, mensitria, SIT wrote in the B, and in the C, SET set I wrote. In the fourth one, D1, I check it, facet, I wrote FSCET. Are you following me?
Yes, sir. Yes, sir.
And now it is only the two. In the two, the right way of writing is only B, because all maxims should be in italics.
Uh-huh.
All
Okay, okay.
maxims should be in italics.
Italic.
So the correct answer is, it's a B, not A.
Option B.
See, this is also a technique they can use it. See, sir, do you point all those things? Yes, I am teaching you the every angle so that my student should not fail in the screening test. See, another point also I can say, right opposite.
Yes, sir. Yes, sir.
What is right opposite?
Sit, set, it is there, sir.
No, I say RIGHT, right opposite, synonym. Antonym.
WR.
Wrong.
Right
Wrong.
opposite, wrong. Okay?
Yes.
And right opposite also left.
Right.
And the right opposite,
Left.
already told.
Wrong. Wrong.
Already told. You are a law student, you are supposed to say, when a person having the right, other person should have the
Wrong.
Duty.
duty. And everybody is right in their own perspective. Right opposite wrong, you are right because you are a son of a traffic police. Because you will say traffic police right and left. And the right opposite wrong, definitely because you are a teacher's son. A teacher always say right or wrong.
Yes, sir.
And a lawyer or a judicial officers, they will say right and duty. And you are right in all three respects. Because you brought up in that different perspective. And hence everybody is right in their own perspective, in their own angle. But a legal point of view, if such a thing is asked, you are supposed to say right opposite duty, not wrong, not left. Why? Legal aspect.
Okay, sir.
Like when I am teaching the law of tort, I teach tree, TREE, tree. Tree is animate or inanimate?
Animate, sir.
See, both the schools are there. If it is animate, why it cannot make the displacement from one place to another place?
But it is growing, no, sir. It has growing.
Means always animate thing should move. But it's growing from the seed to the sapling, sapling to the plant, plant to the bush, bush to the tree. And hence, both are right. Tree is an animate as well as inanimate. You should not say wrong. Okay, now let us go to the point. 18th question. The above Latin maxim constitutes the element of crime. A, first. Second option. Here I should have B. B, second option. And C, third element. And D, fourth element. Now you tell me which element is there.
A, first.
Wrong. We already told you the first element is human being.
Option D, sir.
Wrong.
C, sir. C.
The option
Wrong.
B, second.
It is the second element. It is the second element we should say. The above Latin maxim is the second element. The first element is human being. Is it clear?
Yes, sir.
Now, 19th question. Examples of the mens rea is true. Number 1, intent. Number 2, knowledge. Number 3, rashness and recklessness. Number 4, negligent. A options. A, 1 plus 2. B, 1 plus 3 plus 4. C, 1 plus 2 plus 3. D, 1 plus 2 plus 3 plus 4. Which one is the appropriate answer?
Option A, sir.
A, 1 plus 2.
Wrong.
Option D, sir.
Wrong.
Option C, sir.
Sir, C, 1 plus 2 plus 3, sir.
It is 1 plus 2 plus 3 is the right answer. Intent is there, knowledge is there, rashness and recklessness is there, but there is no word negligent is not there. Hence 1 plus 2 plus 3 is the right answer. Now let us go to the which is true in connection with the example of the mens rea. Again I here made it. And here I made the options like this. Number 1, reason to believe and fraudulent. 2, dishonest and corrupt. 3, allowing or omitting. 4, maliciously, deliberately and warrantarily. A, 1 plus 2. Option B, 1 plus 3 plus 4. Option C, 1 plus 2 plus 4. D, 1 plus 2 plus 3 plus 4.
Option D, sir.
Yes, it there. Answer is a D is there because all elements are there. Mens rea. You can say reason to believe and fraudulent, dishonest and corrupt, allowing or omitting, maliciously or deliberately or voluntarily, etc. Means all elements comes in the mens rea. Hence, the 20th question right answer is D. Now, 21st question. Anyone can unmute and read.
Injury to human beings
C,
is
sir. Section 44, sir.
defined in Section 42, B, Section 43, C, Section 44, D, Section 45.
Yes, now you can give the answer, not in the
Section
middle.
44, sir.
Yes, you are right. It is section 44 defines injury to the human being. Now, 22nd question. Match the following key terms from part A and the explanation given in the part B. Number 1, part A, cruelty is. Number 2, simple hurt is. Number 3, defamation is. Number 4, mischief is. Part B, A, an example of injury to property. B, an example of injury to the reputation. C, an example of the injury to the body. D, an example of injury to the mind. Options are given here. A, 1B, 2D, 3A, 4C. B, 1C, 2B, 3C, 4A. C, 1C, 2D, 3B, 4A. D, 1D, 2C, 3B, 4A. Shoot.
Option D, 1D, 2C, 3B,
Option
4A.
D, sir.
You are right. It is option D, 1D, 2C, 3B, 4A. See here you can see. Cruelty is an example of injury to the mind. Simple hurt is an example for the injury to the body. Defamation is an example for of injury to the reputation. And fourth one, mischief is an example for injury to the property. So when you say the defamation, in the defamation means false statement, or even the sign and symbol also shows the defamation. And he said, if you are not happy with somebody's minister or anyone, and in the four corners you will make and you will burn it as a protest. English lo emanalandi danni? What do you say in English? If you know it, you tell me. If you don't know it, say pass on.
Pass on, sir.
FEG అంటారు దాన్ని. స్పెల్లింగ్ EFF ఇక్కడ చూపెడతాను చూడండి. EFFIGY FEG. FEG also a defamation. FEG images. It is also defamation. చూసారా దృష్టి బొమ్మలు కాలబెడతాను. They are burning it.
It comes also
burning it. So FEG also, it is amount to defamation. Is it clear?
Yes.
Because you are lowering the reputation of a person. Okay, now everybody cannot file a case in that regard because there may be 10 allegations are there, even 5 is also proved, it is amount to not defamation. Okay, now let us come to the point of the 23 question. A intends to murder X for achieving his objective. A mixes a poison in X food and places it on X table. However, Y feeling unusually hungry and rushes and eats the X lunch and dies. A is liable for the A's murder even though he did not intend it. This is known as dash and is mentioned in the dash of the IPC. Option A, intention and 301. Option B, transferred intention and section 301. C, intention and section 302. D, transferred intention and section 302. Which one is the appropriate among the
Option
ABCD?
B.
Option D, sir.
Option B, transfer intention in section 301.
You are right, Sridevi. It is a transferred intention, that is option B and section 301 of the IPC. Even though you want to kill somebody else, but that fellow did not eat, some other of his friend eat, in spite of that also, it is a transferred intention. Yes, it is. You will be tried under the matter. Okay, 24th question. Intention is the IPC is reflected by the terms such as number 1, intentionally, number 2, involuntarily, number 3, willfully, number 4, deliberately. So option A, 1 plus 2, option B, 2 plus 3, option C, 1 plus 3 plus 4, option D, 1 plus 2 plus 3 plus 4. Which one is the appropriate answer?
Option C. Option C, 1 plus 3 plus 4.
Check it again. Yes. The reason is intention is intentionally, but intention is voluntarily, but I wrote involuntarily. That means we can eliminate it. And intention is willfully, and intention is deliberately, and hence the right answer for that here is true is C, 1 plus 3 plus 4. Is it clear? Say yes.
Yes, sir.
Now, 25th question. Dash of the IPC deals with the deliberate intent to wound the religious sentiments or wound the religious sentiments. A, section 295, B, section 295 capital A, C, section 298, D, section 298 capital A. Which one is the appropriate answer?
Option D,
A,
sir.
Say the full.
Section 295, sir.
Wrong.
Option,
Second option.
option
Section
298 A.
298 C.
A, sir.
298 section C.
Yes.
Ade,
Sections 298 means C option is the right option. Section 298 of the IPC deals with the deliberate intent to wound the religious sentiments. So that is the right answer for that 25th question. 26th question. Which option is correct among the 4 regarding knowledge? Number 1. Knowledge is the awareness of the consequences of any act or omission. True. For instance, the bus driver knowledge that if he does not keep his eye on the road while driving, an accident may ensue. 3. Even if he does not intend it. 4. Here the bus driver has knowledge but have no intention to commit an accident. So option A, 1 plus 2, option B, 1 plus 3, option C, 1 plus 2 plus 3, option D, 1 plus 2 plus 3 plus 4. Which option is the appropriate answer here? See, these are the 4 options. Check it once again. Now you can choose from here.
Option B, sir.
Wrong.
D, sir. Option D, 1 plus 2 plus
Option
3
D,
plus
sir.
4.
Option B is the right answer here because knowledge is awareness of the consequence of any act or omission. True. For instance, bad driver knowledge that if he does not keep his eye on the road while driving, an accident may ensue. It is true. Number 3, even if he does not intend it, of course he does not intend it. It's true. And fourth, here the bus driver has knowledge but have no intention to commit an accident. But what is the accident? A wrong calculation is accident. A wrong decision is an accident. A wrong doing an act is an accident. Is it clear? So 27th question. As per the section dash, a robbery committed by dash or more person is dash. So there are three dashes are there. A, 390 and 5 and dacoity. B, 391 and 5 and extortion. C, 391 and 5 dacoity. D, 390 and 5 and extortion. Which one is the right answer?
Option A, 395 and dacoity.
Check once again. Check once again. Which one is the appropriate answer?
Option C, sir.
You are right. It is in option C is the right answer. Section 391, and of course, the robbery committed by 5 or more a person is said to be the dacoity. So the right answer for the 27th question is C, 391 and 5 is the common and dacoity is the last one. So 28th question. Anyone can unmute and read 28th question.
In dash 1932, it was held that the resistance of the victim is not necessary. In the victims seeing a large number of offenders did not resist and
No force or threat was used, but the offenders was still held guilty of dacoity. It is decided in which case law? A, Ram Chance case law. B, Roop Chance case law. C, Karam Chance case law. D, Krishna Chance case law.
Option A, sir. Ramchand's case.
Suppose if I say A, yes, what technology that you used? What equation you used? What parameter you used? Are you read the case law? Are you hunched it?
Somewhere I read that case, sir.
Okay. Even sixth sense also works over there. So the right answer is Ramchand case law. It is decided in that way. 29th question. In dash 1970, it was held that less than 5 persons can also be convicted of dacoity if it is proved as a fact that there was more than 5 people who committed an offense by only less than 5 were identified. However, if 5 persons are identified, out of them 2 were acquitted, the remaining 3 can't be convicted of dacoity because dacoity needs more than 5.
5 or more.
Okay, it is decided in which case law? Narayana Dinba versus Emperor. B, Devi versus State. C, Narayana Dinba versus Emperor. Again, I repeated. And D, Ghamandi's case. Among the
Option D.
option D is the right answer because you got the selected the 3 because the third one I repeated. It's the Ghamandi's case law. It is decided that when the 5 are there, but only 2 are acquitted and the 3 cannot be convicted. Am I right? Because it should be more than 5. So 30th question. In all robberies, there is either A, 1, theft, number 2, extortion, number 3, dacoity, number 4, robbery. Now, option A, 1 plus 2, option B, 2 plus 3, option C, 3 plus 4, option D, 2 plus 4.
Option A, 1 plus 2.
How did you know it's the right answer?
Theft or extortion. All robbery, there is either theft or extortion.
Yeah, just use your common sense, it is enough. Okay, now let us go to the next point, 31st question. In Hushut Sheikh case 1866, C and D were stealing mangoes from the tree and were surprised by B. C knocked down B and B became senseless. It was held to be a case of dash. A. Theft. B. Extortion. C. Dacoity. D. Robbery.
Option B, extortion, sir.
Option A, theft.
See, I have given the case law name here. C and D were stealing mangoes from the tree and were surprised by B. C knocked down B and B became senseless. It was held to be a case of what? So if you happen to read the case law, it is said to be the robbery because there are at least 5 are there, or less than 5. Not because dacoity means more than 5. Only 5 means here.
Theft, sir. Theft. Option A, theft.
No, because they say that there are 3 or 4 are there. Perhaps many are there, but the case law say it is a robbery. It is not a theft. Because here the number is not given. Otherwise, we would have to say it. Because the case law I have mentioned. That is the reason I case law mentioned. Please check the case law, and they said it is a robbery. Is it clear? So, 32nd question. Match the following cases from A and held in part B. And number 1, Rama's case. 2, Duli Ludan Dean Sheikh's case. C, Ramesh Chandra Arora case. 4, R.S. Naik, A. Antule and another case. And the part B, A, robbery. B, theft. C, not extortion. B, extortion. Now is the feedback here. Option A, 1C, 2D, 3B, 4A. B, 1B, 2A, 3D, 4C. C, 1D, 2B, 3C, 4A. D, 1A, 2B, 3C, 4D.
Option C, sir.
Run.
Option C.
Check again. See, I am giving the feedback to you. Rama's case is theft. Dulidon Sheikh's case versus robbery case. Ramesh Chandra Arora case is extortion. R.S. Naik and R. Antule and another is not extortion. And if you see this one, Rama's case, theft. Here theft comes in the B. Am I right? And when you see the Duli Luden's Sheikh's case is robbery. Robbery comes in the A. That means 1B, 2A. Next, Ramesh Chandra Arora case is extortion. And extortion comes here in D. That means 1B, 2A, 3D. Then 4 is the C. The right answer is?
Option B.
Option B, 1B, 2A, 3D, 4C is the right option. So today I made at least 32. And if you happen to see my earlier video clips also, I don't think that there would be some repetition. And this is that I want to share it. And I told you that today is a public holiday. Why public holiday in Tanzania?
We don't know, sir. Tell us.
I posted in the group. Are you not a member in the group?
Yes, sir. Yes, sir.
When you are group member is there, why did not you see? Today is the Tanzania's.
Sir, class is there. Okay.
What is that?
Independence Day, sir.
Independence Day.
Independence Day. I don't think whether you could see the WhatsApp or not. You should see the WhatsApp. It is in the group I posted it. I also told that I am going to start. Is it or not? So
Okay,
now
sir.
next, tomorrow is what? Tomorrow? Tomorrow is 10th.
Saturday.
Yes, sir.
And what is
Saturday.
that I am going to deal?
Hindu
Hindu
marriage
marriage,
act,
sir.
See, I posted on the screen. How many days?
Okay.
Hindu Marriage Act.
How many days?
3
3
days.
days.
3 days.
3 days. Total 3 days.
Yes.
11th, there is a public holiday. Spend your time with your father, mother, relatives, and neighbors, friends. Sunday is not
Yes.
there. I did
Okay.
not
10
write
times.
10, 12, 22 to 12, 12, 22. I did not write. What I wrote? In middle, what I wrote?
Yes.
What I
And,
wrote?
and,
And
What is the Latin terminology for and? Anyone? If you miss my class, you miss many things. Please note the point.
Mhm.
I repeat, if you miss my class, you miss many things. See, Google is also showing the Tanzania Independence Day. Am I right?
Mm.
That is called flag. It's a Tanzania flag. So A and D and equivalent, that is, but it is the symbol is and. The Latin terminology is ampersand. What is that?
at,
And is ampersand. It is called ampersand. Here show you.
Mm. Mm.
It is still reading. Buffering. It is called buffering. Eh? This is Latin terminology. It is called ampersand. Spelling is AMPERSAND. Here I will show you. Did you see now
Mm.
on the screen? What is
Okay.
written here?
ampersand,
Only Professor Hussain students can make it out. Other people, Hapana, Hapana, Hapana means no nothing. Now I am writing slash. It is a slash. What is the style of saying slash? Professor Hussain style? It is called virgule, Virgule, virgule. I will show you virgule image. Did you see the virgules? See, this is the slash actually, not double inverted comma. So it is said as a virgule, which is said to be the slash. Is it clear? Is it clear?
Clear, sir.
yes, sir.
yes, sir.
And another thing I would like to show you is, yeah, this thing that already we did it. And yeah, this we did it. And I also made asterisk. Asterisk is different. This symbol is called not star. Did you see here?
True.
Ampersand,
Mm.
angle bracket, apostrophe, asterisk.
Mm. Mm.
And it is not star. Star is different. And of course, everybody knows this one because you are using the smartphone. Is it not?
Mm.
जनगणमन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंधु गुजरात मराठा हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे अहरह तव आह्वान प्रचारित सुनितव उदार